Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today I'll be joined by Amy Pruett, a partner in our intellectual property practice group here at Williams Mullen. Amy and our colleague Courtney Reigel recently gave a podcast on how using copyrighted materials to train AI datasets is impacting the entertainment industry, in which Amy has significant experience. Today's podcast will update us on recent cases and some of the legal issues involved with using datasets to train AI models. Amy, thanks for joining me today. I know AI has been a hot topic in the legal world, and there have been a number of new cases filed since your last podcast on the Sarah Silverman and other writers' cases against OpenAI.
Happy to be here and join the podcast today. I'm looking forward to discussing some of those recent cases, including some updates to those writers' cases and how the door has opened to similar individuals who've created materials such as artwork, film, news, and other copyrighted content. One of the core issues in these cases is whether copyrighted materials may be used by companies like Meta and OpenAI to train their AI models without the creator's permission.
Thank you, Amy. And I think the cases that we're going to discuss today are going to be pretty interesting. They all bring up a different facet of that topic. And I think everything's just a little bit different to keep things interesting. And last time you mentioned in the Sarah Silverman and other writers' cases was the key issue of what you just described as whether or not using copyrighted material as training information was a violation, AI training information was a violation of copyright owners' rights in their work. But before we get into the specifics of those cases, I thought it might be helpful for us and our listeners to refresh everyone about how certain types of AI models are in fact trained. And in turn, we'll also get into the details of those cases. So to start off, AI software is designed using an algorithm to simulate human reasoning or inference so that the output of a program like ChatGPT mimics something an actual person would write. Specifically, and this might be a term our listeners have heard, a large language model like Meta's Llama AI program is the subject of one of the lawsuits we'll discuss today and is designed to emit natural language. Large language models like Llama are not created by human software engineers writing code like other software programs. Instead, large language models is incorporated when AI is trained by massive amounts of text being compiled from various sources and then is fed into the model itself. The input materials are sometimes referred to as the training data set. The large language model copies the text in the training data set and extracts information from it. After the model is copied and essentially reviewed all of the text in the data set, it can emit convincing simulations of human written language. A question that is coming up in the recent cases we'll discuss today is, and that will impact the entertainment industry, is whether the creators of AI programs like Meta can use author materials in a training data set without permission, credit, or compensation. Amy, now getting into the cases and their specifics a bit, can you give us an overview of what some of these authors are raising in their complaints against the creators of AI programs?
Sure. In the case we mentioned last time, the popular comedian Sarah Silverman and two other plaintiffs, Richard Kadri and Christopher Golden, alleged that their books were included in some of these training data sets used by OpenAI, the creator of ChatGPT, and by Meta for its Llama AI program. One of the main allegations was that a shadow library was used to aggregate books in bulk. These shadow libraries have long been of interest to the AI training community because of the large quantity of copyrighted materials that are available and that they host. But they're also deemed by copyright owners as flagrantly illegal. So plaintiffs alleged that Meta had in fact distributed the Llama models to certain people and entities, benefited financially from doing so, and reportedly made plans to make the next version of Llama commercially available. So plaintiffs raised several counts in the complaint, including direct copyright infringement based on the fact that Meta had made copies of their works without their permission to use in the training dataset, as well as counts of vicarious copyright infringement, saying that Llama's output should be considered an infringing derivative work because it and the model itself is based on their underlying works that were included in the data set. However, in November, the bulk of claims was dismissed other than the direct copyright infringement claim, and plaintiffs were given an opportunity to refile most of their claims.
Thanks, Amy. So can you tell us a little bit more about where we are now in the writers' cases against AI companies?
Yes, in February, similar claims were brought by Silverman and other writers, but they were dismissed other than that direct infringement claim. And there, the judge mentioned the vicarious infringement requires a showing of direct infringement that the plaintiffs did not meet because they didn't allege that the Chat GPT outputs contained direct copies of those copyrighted works or books. Specifically, they stated because they fail to allege direct copying, they must show a substantial similarity between the outputs and the copyrighted materials. Just stating every output of the OpenAI language models is an infringing derivative work is not enough to make a vicarious copyright infringement claim.
Okay, so it sounds like basically we're still waiting to see what the courts may do with the direct copyright infringement claims of these artists or these authors, which primarily appears to center on the issue of whether the creators of AI programs can use author materials without permission to train their AI models, essentially using author materials as training data sets.
That's right. So in similar cases, other writers have also brought class action lawsuits accusing technology-based companies of ripping off their copyrighted works. Specifically, Brian Keane and Stuart Onan filed 2 federal copyright lawsuits in March, one against the state of Databricks and the other against NVIDIA Corp based in Santa Clara, California. And in those cases, the writers alleged similarly that their works were using or being used in a training data set that Databricks unit Mosaic ML used for its large language model called Mosaic ML pre-trained transformer. The writers claimed in that case that during the training, the LLM copies and ingests were textual work in the training data set and extracts protected expression from it. The LLM or large language model progressively adjusts its output to more closely approximate the protected expression copied from the training data set. Similarly, early this May, nonfiction writer Susan Orlean and a short story writer Andre Dubus III filed a similar action against NVIDIA, and popular novelist Rebecca Mackay and poet Jason Reynolds against Databricks. Neither case mentions which specific works were used in the datasets, but they do claim that the software copies and ingests each textual work by within the training dataset and extracts protected expression from it. So they're generally claiming that it's copying the works by being used in the training dataset. An NVIDIA spokesperson has also stated that they believe they created their models in full compliance with copyright law. So it remains to be seen.
Absolutely. And thank you for sharing that, Amy. And actually, I wanted to share a few cases that I think pose a unique and maybe interesting twist on what you've just discussed. So there was a case in California, and it was brought by 3 artists against companies that I think many of our listeners have likely heard of: Stability AI, Midjourney, DeviantArt, and Runway AI, which are all various assorted AI platforms. And the court in that case decided against the AI companies who are defendants and refused their motion to dismiss. And basically, and the case will proceed on whether or not the companies were responsible for infringement based on their use of artists' work. And what is alleged to have happened by the defendants is that they did not, in fact, directly infringe any of the artist's work. They, in turn, used a tool, Stable Diffusion, to actually, and the tool itself went and retrieved artist work, which was in turn used as data set material. So it is the position of the AI platforms that they themselves did nothing but use a tool. They themselves did not infringe. And so it will be an interesting question as to whether or not such conduct where the companies themselves, I suppose, did not retrieve the material for data training set material, whether that comprises infringement. And there was also a similar case brought by a group of artists against Google's what is known as text-to-image artificial intelligence tool known as Imagen. And Imagen uses machine learning to generate an image based on a short text description inputted by users. And the class action essentially says that what Imagen does infringes the rights of the authors. And the plaintiff in this case is a photographer, along with 3 cartoonists and illustrators, basically said that their works were used without permission, and they're hoping to bring in a larger class action. But basically, they're saying that what Imagen does also infringes the artist's copyright rights in their work. And Imogen is not the only model such as this. There are a few others also provided by DeviantArt and Runway. But it just brings up an interesting question as to whether or not this particular mechanism, where I'm not necessarily copying an image straight out of, say, a website, but I'm using a tool that allows me to input a textual description, and based on someone else's work of a textual description, whether or not that amounts to infringement. So it's an interesting question, and it will remain to be seen how the court decides.
Definitely interesting issues that are coming up in this, especially as it pertains to the users that are using the AI and whether or not the tool itself is infringing. And the cases do continue to develop. There were training data sets aren't the only issue. In a recent case brought by 8 regional newspapers, OpenAI and Microsoft were also accused of ripping off newspaper copyrights and misappropriating news articles to train their AI chatbots and spread fake news. So specifically, plaintiffs allege the defendants used their copyrighted publications to train their AI products like ChatGPT and Copilot without the newspaper's consent. And they opined that newspaper publishers spend billions of dollars a year to send their own journalists to cover important events, and defendants' AI tools are taking the publisher's work and using their journalism to create Gen AI products that undermine the publisher's core businesses by republishing their content for free, and sometimes it's even fake content. The suit also claims that the AI companies are damaging the publisher's credibility by falsely attributing inaccurate reporting to those publisher newspapers and spreading dangerous disinformation.
Thank you, Amy. And one case I really wanted to discuss, which brings up a very interesting issue relating to the concept of copyright fair use, is a case involving the Oscar-nominated film The Holdovers, which is a film by Alexander Payne. So a screenwriter, Simon Stevenson, alleges that the film infringes or has plagiarized his unproduced screenplay for a work known as Frisco. And the screenwriter asserts that not only is there similar scripting, but there's also a relatively high level of similarity in characters and structures and themes. And so this brings up whether, and the script was written using AI. And this case brings up whether or not use of work as training material for an AI platform actually rises to the level of fair use. So to put this case into context a little bit, many of our listeners may have remembered Google's book project. And that was a project whereby Google scanned many, many, many books without authorization or license from the authors. And after the scanning, they made small portions, or what we might call snippets of the books, available in response to searches. So if you're looking for a particular work, you can, I suppose, confirm or read a small portion of what Google had scanned. And in the case of this work, one of the issues is whether or not the use of the screenplay as training material such that the AI platform was able to generate what is alleged to be a very similar script for separate work comprises fair use. And what AI platforms have asserted, and I think the conflict is what our listeners might anticipate, which is that authors believe use of their works as AI training materials is an outright infringement because it's use of their work without permission or license. But the platforms assert that such action comprises fair use, and they rely on the Google Books project as a point of contrast, whereby in the Google Books case, which was actually in fact deemed fair use, in 2015 in the Second Circuit. In that case, the works were stored and made available after storage. In the case of what training material, how parties engage with training material is that once the material is inputted as training material, there is not a version or copy saved, such as in the Google case, and it's not displayed. And so there's a lot of interesting discussion around whether or not the Google case and how training material in fact differs from what Google does, which was already deemed fair use, might push the AI platform's position of training material being fair use to also being deemed in a court case fair use. So it's very interesting. And AI models, when you are inputting training material, they can actually provide generally 3 different kinds of responses. So once you've inputted the training material, AI might respond with a verbatim version of what you've inputted. It might also provide something that's paraphrased, or it might actually provide something that is similar in idea. So it's interesting in terms of what writers and AI platforms, their respective positions and how this impacts an analysis of fair use. So we'll be watching that. And if there is a definitive case, we're happy to update our listeners, but it's definitely a tension there that has not been definitively decided. And I think it will be certainly discussed more frequently and I think litigated in the not too distant future. So with that, Amy, I turn it back to you.
Sure, it does certainly seem that we may have some time before there's a real clear decision on whether the use of copyrighted content to train AI programs is fair or infringing, and whether the tools itself are not even copying or making copies of the originals to begin with. And if they aren't storing that original material, how can it be infringing? In the meantime, it may be important for AI users and creators to do a little bit more diligence to ensure that their works are not infringing.
I agree, Amy, and I really appreciate our time today discussing this. I think it's been important, and I think it raises some very, very useful and important considerations, whether you're on the AI platform user side or whether you're on the creative side. And I think providing this information will be really, really useful for our listeners. So I really thank you for providing this information to our listeners of Trending Now and IP Podcast. I believe that's going to wrap up our discussion of AI and its potential impact on authors, filmmakers, artists, and other creators. We'll look forward to what comes out of these cases as well as any direction from the Copyright Office. Listeners, if you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.